Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 200 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice. And I'm pleased to say I've reached 200 episodes. Woohoo! It's only taken just under 9 years. So I started the podcast in August 2014. So, yes, it's taken a little while to get here, but I got to 200 episodes. So thank you very much for listening and tuning in. Hopefully I've got an entertaining and informative episode for you where I'm going to be covering off a couple of cases that have been in the news recently. So without further ado, I'm going to get into this week's featured content. So the first case that I want to talk to you about is a case that's been in the news in relation to indirect discrimination. And this is indirect sex discrimination. Now the case is Miss Glover versus Lacoste and one other. And the other respondent was the HR business partner for Lacoste, who were Miss Glover's employer. So Miss Glover was employed as an assistant store manager for Lacoste, working over 5 days a week flexibly for 39 hours. She then went on maternity leave, and before her maternity leave came to an end, she made a request for flexible working, as many mothers do, and she requested to work 3 days a week. Her application was originally rejected, and her employer then went on to deal with it under appeal, so she appealed against the decision to reject her request. Her appeal was partly upheld in that they offered her 4 days a week, so they said you could work 4 days a week. However, that would need to be flexibly worked on any day. So they couldn't actually fix the days of the week that she would be required to work. And this was on the basis that she was an assistant store manager, so in a senior role in the business. Now, for anyone who has children or tried to set up nursery arrangements or childcare arrangements for children, unless you've got retired parents or retired relatives who will have your children whenever you need them to, it's very difficult to arrange flexible childcare. Nurseries, for example, and preschools need to know exactly when the child is going to be there for staffing levels. So it's really hard to get childcare arrangements flexibly, so not knowing from 1 week to the next when you might be working. So because that wasn't upheld and Miss Glover couldn't do the 4 days flexibly that they had said, she then contacted solicitors who wrote to her employer on her behalf and basically said that she would be pursuing a claim for constructive dismissal. As a result of that solicitor's letter, her employer then conceded to her request and said, yes, actually, we will allow you to do what you've asked for. So just in terms of the timing here, her solicitors wrote to the employer on the 14th of April 2021, and on the 23rd of April, they wrote back to Miss Glover and accepted her original request in full. So she was still on furlough at this time, because as you know, at that time it was the lockdowns and that sort of thing. And so she was told that she would return to work on the 25th of April 21, which she did, and that was on the basis as set out in her flexible working request. She then subsequently submitted a claim to the Employment Tribunal on the 4th of May 2021, originally asserting a breach of the flexible working provisions of the Employment Rights Act and also indirect sex discrimination. She subsequently withdrew the flexible working complaint, but the sex discrimination claim continued. Now, what's interesting about this case is that the Employment Tribunal at the first instance found that the requirement to work flexibly was a provision, criteria or practice which had an adverse effect, and had it been applied, it would have been discrimination and there wouldn't have been a justification for it. But actually what happened in the case for Miss Glover is that her claim failed at the Employment Tribunal because the Employment Tribunal concluded that the PCP, the provision criteria in practice, was not actually applied to her, and so she hadn't suffered a disadvantage. So because the solicitor's letter had effectively worked and her employer had agreed to the original request, the provision criterion or practice, which was being alleged as the thing that was causing the disadvantage, hadn't actually applied to her. So her claims didn't succeed at the Employment Tribunal. Now, what the Employment Appeal Tribunal did on appeal was to review the case and ultimately conclude that the Employment Tribunal had been wrong at the first instance to reach the conclusion that they had. The Employment Appeal Tribunal debated previous case law in relation to what is called disappearing discrimination. And so it's this idea that if the discrimination or issue has been rectified, that there is no discrimination. And so there's quite a lot of debate within the judgment, if you're interested, to read through about that. But ultimately, what the Appeal Tribunal decided was that there is only one possible answer to the question of whether the PCP, the provision criterion or practice of requiring flexible working, was applied. In this case, it had been applied to Miss Glover at the determination of her appeal. So at the point in time in which the employer concluded the appeal and made the offer of 4 days flexibly, that's when that provision had been applied to her. So the question of whether Miss Glover was subject to disadvantage or detriment by the application of that flexible working provision has to be remitted back to the Employment Tribunal to be reconsidered. The Appeal Tribunal then went on to say, having regard to the authorities we have set out as to what constitutes detriment, it's hard to see on what basis it could be held that there was no disadvantage or detriment to Miss Glover when the appeal was determined against her, and she felt she had to consider resigning from her employment with Lacoste. However, it's for the Employment Tribunal to determine on the facts whether there was a specific disadvantage or detriment suffered, and then to assess injury to feelings. So in short, the Employment Appeal Tribunal overturned the decision of the original Employment Tribunal that there had been no detriment because the provision, criterion or practice hadn't actually applied to her, because when she'd returned to work, she was working on the original flexible working basis that she'd requested. The Appeal Tribunal said that was incorrect to find that, because actually the provision that was detrimental or potentially detrimental had been applied at the appeal stage. And so now the case will go back to an Employment Tribunal again to reconsider whether there was disadvantage in relation to that decision. Now, what's most interesting about this case is, of course, this notion that many employers have, that employees have to work full-time or have to work set hours if they are going to be in a management position. I recently spoke to somebody who worked as a manager for a large national retailer, and he was trying to get flexible working requests through on the basis of his ill health. He needed to reduce his hours, and he was being told by them, you can reduce your hours, but you can't be a manager, so you have to take a step down. Now, of course, in that situation, it's slightly different. We're talking about a potential disability here, and he's going to pitch it as a reasonable adjustments request. But it is interesting that those businesses who have this criteria in place, that you have to work full time, for example, to be a senior manager, are narrowing the pool of talent that they have access to for management roles, as well as, of course, creating a disadvantage to women who still predominantly have the childcare responsibilities, and also to those with disabilities. So an interesting case to watch to see if, one, it actually does go back to the Employment Tribunal or if it's settled, because that often happens, and what the outcome will be if it is heard by an Employment Tribunal again. I will put a link in the show notes so you can find and read the judgment if you want to. It is interesting if you're looking into that sort of thing or you have a potential case yourself. Now, the second case I want to talk about very briefly is a case which was held in the Employment Tribunal. The hearing was last year in June and July, and the judgment has recently been produced online and then subsequently reported. Now, this is a case the claimant here is Miss Dadhania, and there were several respondents, including her employer, SAP UK Limited, and a number of other people were listed as respondents. It's a claim for constructive unfair dismissal, and also Miss Dadhania claimed for direct discrimination, harassment and victimisation on the basis of age, race and sex. Now, her claims for constructive unfair dismissal were successful. Her claims for discrimination were not. Now, the reason it's an interesting case and the reason why it's been reported is in regards to some comments that were made by the judge in the outcome. Most notably, in regards to a comment that was made by the claimant's manager. He's alleged to have sworn at her using the F word in the context of a discussion. He said, or is alleged to have said, "I don't give an F that Shane is sponsoring it." Now, the gentleman denied this, but the Employment Tribunal believed the claimant's account in this case. And in the judgment at paragraph 36, they say, and I'll read it for you because I think it's interesting, "The tribunal have concluded that we prefer the claimant's account to that of the respondent's evidence on this issue. We considered the claimant a believable witness and do not consider it as something that she is likely to have made up. The words allegedly used in our view are fairly commonplace and do not carry the shock value they might have done in another time. It is in our view something that might have been said and is now recalled by Miss Jane and Miss Shate because of its lack of significance. It is in our view something that might have been said and is not recalled now by other witnesses because of its lack of significance at the time." So that's interesting that the judge in this case should conclude that the words allegedly used are fairly commonplace and don't carry the shock value anymore. Now, when I've talked about swearing in the workplace previously to clients, I've always said it's taken in the context in which people work. So very typically, you would say you could expect to hear foul language in a setting such as a building site and not so much in an office. So the acceptability of the use of swear words would depend on the context in which somebody worked, and that would be the advice that I would normally give. But clearly, what the judge is saying in this case is that actually it doesn't have that same shock value anymore. And so it's not necessarily the case that an individual can rely on somebody swearing at them as something serious. Of course, each case must be taken on the individual circumstances and the persons that are involved, but in a situation where an employee might have sworn at another employee or even at a customer in the past, you might have said, well, that's serious misconduct and that's something that we should dismiss for. The changing views on language and what we're using and the way that people use it means that actually I think we should probably be thinking twice about whether the use of profanities is actually misconduct. I'd be interested to hear what your views are on that. And it makes an interesting point in this case. The other thing about this case, which is something that you should be aware of, is actually in regards to the tribunal's assessment of the claims for discrimination, victimisation and harassment is very interesting and quite helpful if you're dealing with a similar case or a case where these kinds of complaints are being made, because it goes through the analysis of each of those. And whilst they find that clearly there was poor behaviour on the behalf of the respondent here and that the claimant was treated in a manner which would allow her to resign so as to breach the duty of trust and confidence, they found that there wasn't evidence upon which they could find that the conduct that was taking place was actually because of a protected characteristic. It just shows the high bar that claimants have to go through to be able to prove discrimination, even where the employer's behaviour is not as it should be, I suppose. So again, I'll put a link in the show notes to that so you can have a read through if you want to. And certainly if you're thinking about defending or bringing a claim in relation to discrimination, it's helpful to have a look at these kind of judgments to see exactly what the thought process is of the Employment Tribunal. Because what you can do then is, of course, you can tailor your claim or your defence based on the way in which tribunals will look at it and make it a lot easier for the tribunal to find in your favour. So there's 2 cases there that are of interest, I hope, and that you will find helpful in your day-to-day application, either as a litigant or as somebody who works in HR, or if you're defending a case as an employer. If you find yourself on the wrong end of an employment tribunal claim, then you can always get in touch with us. Myself and my colleagues are all trained and qualified solicitors with years of experience of advising employers in the employment tribunal. We also act for employees, so we are used to dealing with both sides of things, and that can help us when we are defending a case for you. If you'd like any advice or assistance, you can get in touch. My email is alison@realemploymentlawsadvice.co.uk. And as this is my 200th episode, I'm just going to ask you if you wouldn't mind giving a like, a subscribe, leaving a review, wherever you might be listening to this podcast. It would really help me out in growing the audience again, getting more people to listen and to spread the word about good employment practices. Thanks very much for listening, and I'll be in touch in another 2 weeks. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.